Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to tackle a somewhat imposing project in that I'm going to look at a video that Massad Ayoob gave to Active Self-Protection Extra, in which he discusses what you should say or not say to police after a self-defense incident. Now, this is a bit of a big undertaking because if you don't know who Massad Ayoob is, he's a major figure. He was a police officer for many years. He taught self-defense. He's published a tremendous number of works on the subject of self-defense, on legal issues around self-defense. He's been an expert witness. He's done quite a number of things. So he's a bit of a legendary figure in this sphere. And so, and he's somebody who I have tremendous respect for. Now, I'm going to disagree with him on some things here, but again, this is somebody I have tremendous respect for. I don't know that he's got the same respect for defense lawyers, but you'll see that a bit in the video here. But I want to sort of go over what he says. I'll, let him sort of provide his view, although I'm going to cut this down as much as I can just for brevity. I'm also going to recommend check out the original link. I'm going to post it up here, hopefully. So go check out the original link so you can see this all uncut, unedited. But I'm going to try to address what he says and offer sort of a counterpoint, or in some places agree with him. You can make your own decisions, but I'm going to explain sort of why I think what I think and sort of set that out. Fair number of people have actually pointed me to this video and said, what do you think of this? This isn't really what you've been saying. So I want to address this and let you guys decide. So without any further ado, on to the video.
Why do you think it's a bad idea to just completely invoke the right to silence?
Well, you remember when your little mommy told you you only have one chance to make a first impression? Mm-hmm. That's true of the responding officers and investigating officers at a shooting scene as well. Now, their training, and for most of them, most of their experience, has been when they get to a scene where one person's horizontal in a puddle of blood and the other is standing there with a smoking gun on him somewhere, generally, whoever's horizontal turned out to be the victim. Whoever put him horizontal turns out to be the perpetrator. So here's your first impression, and that's not good.
So the crux of this argument is that, upon the police showing up, they see a dead guy either in your living room or maybe out on the street somewhere. And, they're immediately going to assume that, you're the bad guy because he's the dead guy. And that this is your chance to tell the police, no, I'm the good guy, and maybe shape their investigation. The problem with this is here in Canada, the police don't really tend to sort of be easily swayed out of this. You should assume that if there's a dead guy or a badly injured guy, that the police are going to charge you. And in my experience, the more you talk, the more likely that is for various reasons. Largely that you make their evidence collection a lot easier. So this notion that you can convince the police that you're actually a good guy, I think that works better for somebody who might be Mr. Ayoob, especially somebody who can pull out a police badge. But for you and I wouldn't try it. Ultimately, the police, you should expect that they're going to lay charges no matter what you say, and that what you say may make that, in fact, easier for them to do.
Now it gets worse. All his experience has been that when he's got a genuine victim, says, buddy, what happened here? They say, that SOB did this awful thing, and I'll testify against him in court. And every perpetrator they got, they say, buddy, I'm willing to hear your side. They say, I ain't telling you nothing till my mouthpiece gets here.
Now, you can see that he does not much care for defense lawyers here. And the argument is basically, you will look guilty if you want to talk to a lawyer rather than cooperating with the police right away. Well, that doesn't make you look guilty. It makes it look like you know your rights and that you're standing up for them. I'll tell you that police, when they're facing, potential legal jeopardy, they want to talk to a lawyer right away. They're not going to wait. Guilty people need lawyers. Innocent people need lawyers. People who don't know whether they are guilty or innocent also need lawyers. So this notion that you're going to, convince the officers that you're a stand-up guy and that they should, not charge you because of that, I don't see it. I mean, I see plenty of situations where the police have said, we are not sure, we think that this person was cooperative, but they still charge them. I mean, they're going to want all the forensic information. They're going to want, to conduct a full investigation. It's not like the police are going to go, well, this guy seems like a nice guy. I'd totally go for a drink with him, and he didn't call a lawyer. So, you know what? Let's just call this a day. We've got a dead body here, but we'll just, no biggie. Off you pop. That's not how it's going to go. Don't assume that you're going to just charm your way out of a dead guy. You can't charm your way out of a dead guy in your living room. It's just not going to happen. So I don't agree with this particular bit of advice. A lawyer here can help keep you from saying something that will ultimately convict you or ultimately make things a lot more difficult for you at a later trial. And I'll talk a little bit more with sort of specific examples and references to a particular noteworthy case, but let's continue and hear more of what he has to say.
Now they're on the scene. He's horizontal, even though he's the perpetrator, doing a very convincing imitation of a victim. You're vertical.
And this really illustrates the problem with this strategy of trying to convince the officers that you're the actual victim, is that the other guy's got a real convincing advantage on that score, in that he's got a hole in his chest. That shotgun blast to the chest is real convincing on that score, and I don't think that you're going to be able to talk your way out of that particular issue.
He's managed, or one of his friends has blurted, that evil man in the black shirt with the Mantis logo shot my friend for nothing out of savage bloodlust. Ask you, sir, what's your side of the story? I ain't telling you nothing until my mouthpiece gets here. Now, you won't be using those exact words, but you know that's how it's going to be heard. You have just set the stage. And from there, it's gonna go.
And so in your mind, you say, listen, that can get rebutted, that can get changed, but you're setting things in motion that you don't want to head that way.
It's going to be an uphill fight for the attorney.
So he says that it's an uphill battle if you haven't provided a statement. In my experience, it's exactly the opposite. When I see a file and there's no statement from the accused, that's downhill skiing. That's where I want to be, because that's what gives me my best chance of winning at the trial. If you've provided a statement, it's likely that you will say something that in some fashion incriminates you or helps the Crown prove an issue they would have otherwise had to call evidence for. So I might be in a situation of having to fight a second battle just to keep that statement out, and I might lose that battle depending on the circumstances. So having to fight two fights is obviously harder than fighting just the one fight. The next thing is that even if you don't say anything harmful in that statement, I can't use that statement to your benefit. But the Crown can use it against you, because if you're going and you're testifying, and you may have to testify at a self-defense trial in order to establish what you were feeling, why you took the steps you did, and so forth. But when you get up to testify, any differences between your testimony at the trial and that statement are going to be used against you in a fashion to suggest that you are in fact a liar. And that's not a good thing. But keep in mind as well, this, the situation of the immediate aftermath, the police probably aren't going to be sitting there with recorders. They're going to be writing things down. And if your statement at trial differs from what the police officer wrote down, which might be a misunderstanding, a misinterpretation, all sorts of ways that there can be, confusion or error in terms of what gets onto that pad, they'll still suggest that you're the liar if your statement at trial is different. The best situation, if you have to testify, is that your testimony at trial has never been heard by the police or the Crown before, because that means that they're unprepared for it. They don't have a plan of attack for how to counter you. They have to think of that right then and there. They have to react to it in real time. That's much better than if they've already planned for how to defeat you a month ago. And, there's not a second version of it that they can use to challenge you with. So I don't want to see a statement on disclosure. It is the first thing I probably check when I get a disclosure package is, Did my client say something? And if so, how dumb was it? Please, no statements. No statements is where I want to be.
Well, there were 3 deadly threats when you drew your weapon.
Yep.
2 of them now remain at large. You don't tell that to the police. You don't tell the police what they did. You don't give them a description. And now 6, 8 months, maybe more than a year later, we're trying to establish you are the good guy. And on cross-examination, you got, let me get this straight, Mr. Correa. You want this jury to believe you're the good guy, the sheepdog that protected the poor lambs from the wolf. And yet, you knew 2 savage predators were still up and running, threatening that community, and you didn't bother to tell the police. How are you going to get past that?
So to my mind, the way you get around this is that this question is objectionable. When he's going, yet you knew, that's the point where I think a defense lawyer who's on the ball would be shooting up to their feet saying, objection, and having the jury removed from the courtroom, assuming there is a jury, and saying, my lord, with respect to this matter, my friend is asking the jury to draw an inference of guilt from my client's exercise of charter rights, and ideally citing the case law and so forth. And hopefully the court would be saying, Crown, you don't get to ask that question because that's exactly what you're doing. You're asking the jury to determine this individual is guilty because he didn't provide a statement, because an innocent person would have provided a statement. That's an improper inference. So that's how I think you get past that, is that that question should not be asked in a courtroom and should be shut down by counsel.
So what I'm going to suggest to you is this, the 5-point checklist real quick. First, establish the active dynamic. And the active dynamic of what happened is not that you shot him. That's got to be patently obvious. It's whatever he did that forced you to shoot him. This man attacked me, this man pulled a knife on me, whatever it was. Second, reinforce that. First, you've made yourself the victim complainant. You've established that. Okay, we've got a good solid foothold on the truth now. Second, confirm that. Make a statement to the effect that you will testify against him.
So you might be thinking, well, I'm not telling the police that much here, so how could this go wrong? Well, first thing, once you start talking, you're going to find it real hard to stop talking. But the second thing is even just this little bit to sort of set the stage as a self-defense situation is actually giving up a lot. Because if somebody comes after you with a knife and you guys struggle and he ends up getting stabbed with his own knife and, is laying there dead on the sidewalk, the Crown ordinarily has to prove how this happened. They have to prove, for instance, that you were involved and not a bystander who came in to provide aid. Now, your testimony might establish that, but otherwise they're going to have to do it with forensics. So if you just say nothing, and again, you don't want to lie to the police. Lying is much worse than saying nothing. But if you say nothing, then they have to figure that out. They have to gather evidence to prove that you were actually involved in the altercation and not simply present. Otherwise, they're going to have a very hard time even bringing charges. So you give that up when you say, yeah, this was a self-defense situation. Another example is, let's say somebody comes to your house and they've got a fire axe, they've got a hockey mask, and they chop down your door. They're yelling that they're going to kill you. They get in the door and you shoot them with a shotgun. They are lying there on the ground. But let's say you've got several people in your house. There's you, your spouse, maybe some adult or, older kids who could have wielded a shotgun. If none of you say anything, the Crown's got a real problem because somebody shot this guy. But they have to figure out who to charge. But the instant you say, he was coming right at me with the axe, now you've established who did it. So you've given up a fair bit. The other thing is about this statement about, I will testify. Because ordinarily, you have a right not to testify. And in fact, the Crown can't suggest, well, look, he didn't testify. So, but once you've told the police, I will testify, and that might end up on a recording. It might be something that they play as part of all of this. And so now you've told the police that you're going to testify, but it might actually not be a good idea to testify at the trial. but the jury might still hear your promise that you're going to testify. That's going to cause some problems. That's going to have people, on the jury asking questions. So that's not a statement I'd want to make at this stage. Again, I think you're better off saying nothing, especially because maybe Mr. Ayoob could navigate all of this under stress. You're going to be in the worst adrenaline dump of your life if you're ever in this situation. You're not going to be thinking clearly. You'd probably be thinking more clearly if you just got to the bottom of 4 or 5 scotches than if you've just survived a life or death situation. I have not been in many life or death situations, but I did go off the road in my car and I thought I may well die doing that. I will tell you, I was not terribly coherent right after that car stop. I mean, obviously I'm fine, but that experience of, thinking that I was about to die really messed with my head for a good probably 30, 45 minutes. Do you really want to think that you're going to navigate this successfully and give only the information that helps you with the police and nothing that really screws you up later on? Because I don't think I could do it, and I've got a legal education. If you don't, I don't think so. So I'd be very cautious about this advice. I don't think it's great advice here.
Third, point out the evidence. We went into exhausting detail in this class on how evidence can get changed, altered, disappeared. Often, if you've shot them up badly enough, they're going to use a medevac. You ever see what when helicopters land nearby, what the wind does to everything on the ground? Stirs up the giant tsunami of sand. The spent casings blow everywhere.
God forbid the fire department shows up and the evidence eradication team is here.
Cops jokingly call the first medical responders the evidence eradication team because in their job and ours, all first responders, life is the highest priority. They are wearing big, heavy emergency shoes. They are running to the scene to get to the victim to try to help him. They are rolling the gurney across. We've seen spent casings get caught in boot treads, get caught in the treads of gurneys, get caught in the clothing of the man you shot if it happened at close range. Let's say I'm left-handed with a conventional pistol with the right side ejection port. As I fire here, shell casing comes up here, gets caught in your clothing, and somewhere between here and the sidewalk falls out. It's going to look like I shot you out there, and I'm lying about having shot you in here. We've had cases of witnesses picking up shell casings for souvenirs.
Wow.
The bad guy drops his weapon. Particularly in certain inner city areas, a weapon dropped on the street has the same survival life of a Corvette Stingray with an open top and an open door and keys in the ignition. If you don't point out the evidence as soon as possible, it can get moved or lost. And it will never come back to exonerate you and confirm your story.
Now, this one I'm kind of mixed on, and I'll explain why I'm sort of mixed here. The first thing is, let's talk about the effect of missing evidence, because missing evidence generally goes to the favor of the accused, not the Crown. And the reason for that is that the Crown typically bears the burden. So in terms of a self-defense argument, there's actually 2 hurdles that need to be overcome. And the first hurdle is on you as the accused. And that is that there has to be an air of reality to the self-defense argument. So, for example, if you walked up to somebody who is just standing on the street, and this is seen by a whole bunch of witnesses, and you say, you don't say anything, maybe you just pull a gun, put it to the back of his head, and shoot him, you're not going to be able to present a self-defense case to the jury. The judge is going to the justice is going to shut that down and say, there's no air of reality to you shooting a guy in the back of the head who didn't even see you coming, that was self-defense. So that argument just doesn't exist. It doesn't go any further. But once there is an air of reality, then the Crown bears the burden of proving beyond a reasonable doubt that it wasn't self-defense. You don't have to prove it was, they have to prove it was not. So holes in the evidence where you can't prove anything one way or the other go to your benefit, not the Crown's. So all of this stuff about, the evidence eradication team and so forth, I'm going, okay, so the evidence gets wiped out. That tends to lead to the favor of the accused rather than, again, the prosecution. However, there are some bits of evidence that I would not want to see lost. And the big example that he gives is, the handgun that's in the other guy's hands, because, that's a big deal. But it's kind of hard to see how that would get lost, assuming a moderately competent investigation team. There's a dead guy on the ground, there's a handgun right next to him. Somebody's going to point this out. The EMTs, if they see a gun, are going to be like, whoa, you need to see this. Fire department, same thing. If there's a handgun on the ground, they're going to be like, hey, police, handgun right here. Police, if they see it, are obviously going to take pictures, put it into evidence. That's not something, so the only circumstance I could see is some way where this is possibly, hidden or the like. In which case, this may be a situation where you want to point it out, but I'd want to get on a phone and talk to a lawyer and ask them, hey, should I pass this information on at this stage or not? So this is a great time to get a lawyer on the phone to answer that question, because the lawyer is going to have a better impression of whether that's something you want to be volunteering at this stage. And further, if you call your lawyer and the lawyer says, okay, so, the handgun in his hand, you saw it slide under the car and drop into the storm drain. Is that correct? You say, yeah. The lawyer might say, I'll pass that information on. You stay quiet, because the lawyer passing that information on isn't an admission from you. So there's benefits to having it come from your mouthpiece instead of from your actual mouth, which apply in court. So on this, I'm a little mixed, but I still lean very heavily towards keep your mouth shut and let your lawyer do the talking on this point for you.
Fourth, point out the witnesses. You're all familiar with the history going back to 1973 and the murder of Kitty Genovese in New York. All those people who heard her scream, help, he's stabbing me. And only one, finally, when it was too late, picked up the phone to call the police.
It's worth noting that the sort of popular understanding of the Kitty Genovese story is actually a little off, because in fact several people did call the police apparently, and the police just didn't respond until eventually they got a call that they felt they had to respond to. So this is maybe not the best example here.
And the syndrome was called, I don't want to get involved. Well, if you point out the witnesses before they decide they don't want to get involved, now they're on the radar, and now the statements that would exonerate you are not lost. And people always ask, well, what if the witness is a gangbanger buddy of the guy I shot and he lies about me? No crap, Sherlock. He was going to do that anyway. That's your attorney's job to break the lie.
He's right when he says that it's part of the lawyer's job to counter lies that are being told about you in court. However, it's part of the lawyer's job because it's work, and it's work that's on your dime. If it's going to take an extra day of trial to get through this additional witness, well, that day of trial you are paying for. And think about what's in it for you about this sketchy friend of the deceased testifying against you. If you show that he's a sketchy liar, well, how ahead of the game are you based on if he wasn't there? Maybe a little. You can be like, why would his friends be lying unless it points to a self-defense situation? But that's not much. That's not great. That's not a big advantage over that guy just not being there. So I don't think there's actually that much to gain from the guy's sketchy friend showing up. The police have a lot of advantage to that. They can use that, person's evidence to testify against you. But I don't really see what's in it for you as the accused to have the deceased's buddies testifying against you. The other thing to consider is that the most dangerous witness is not going to be the sketchy buddies of the sketchy guy who attacked you. It's going to be the honest but mistaken witness. What this means is somebody who, isn't friends with the deceased, so they're not there isn't that conflict of interest, which makes it seem like they're a disinterested party that would have no reason to lie. And they're going to present as though they're telling the truth because in their mind they are. They're telling what they saw. They're telling how they understood things. But let's say, for example, you're attacked on the street by somebody who pulls a gun on you and you happen to have a pocket knife and you happen to prevail in that particular confrontation. But this witness sees it maybe in, not the greatest of light and maybe from 50 feet away. And when they're asked, so did you see a gun in the deceased's hand? They say, no, I didn't. And the officer says, well, are you sure? And they say, yeah, I'm sure I did not see a gun. I guarantee you that by the time trial rolls around, that I didn't see a gun is going to have transformed into he didn't have a gun. At which point the question becomes, where did that gun come from? Well, the implication is maybe you put it on him after the fact. So that witness, might be incredibly destructive to you. And, they're not trying to be. It's not that they, that they think they're lying about you. It's just that they don't know what really happened. That witness is way more destructive than the guy who's sort of obviously there and obviously lying. But if that witness isn't there, again, this is a situation where ties go to the accused so long as you've got that self-defense as an air of reality. I would rather that witness not show up. So the assumption that a witness is necessarily going to be to your benefit, I think isn't really one that I can, get on board with. Just because you're the good guy in an altercation doesn't mean that's what the witnesses are necessarily going to have seen or to have said. And you run the risk that that witness that you point out might be the witness that convicts you. Whereas, again, gaps in the evidence tend to go to your favor. So again, I'm not really sure here. The other thing is, if that witness, if you know who that witness is, you can identify that witness. Your lawyer can make contact with that witness, find out what they're going to say and whether your lawyer wants to subpoena them. Because if that lawyer is helpful, why not bring them on as a defense witness? That's entirely something that your lawyer can handle, after the fact. There is, of course, the possibility that some of these witnesses might end up being lost, but I don't know that you are going to be knowledgeable enough here and to have enough of an understanding to make the call as to whether that's actually a witness that you want to bring in on this. Again, really helpful for the police if you point out all the witnesses, but maybe not super helpful for you as the person your life is at stake. So do you really want to gamble on that, I guess, is the question.
Finally, it's at that point you need to shut up. Not say nothing to the police, but, officer, you're going to have my full cooperation after I've spoken with counsel.
So for this one, that statement itself would be making a promise that you don't plan to keep. And this statement is actually worse for the Canadian perspective. And the reason why is because in the US, your right to counsel includes having a lawyer present at the interview. But in Canada, that's not what you get. They'll take you into custody. They'll put you in a phone room. You'll talk to your lawyer, and then they'll take you out of that phone room, and now you're on your own, and now they'll put you in that room. And then they'll say, you said we would have your full cooperation once you talk to a lawyer. So they'll use that statement to browbeat you, and this statement doesn't get you out of trouble here. Officers will actually try to get people to make statements like this in order to be able to pressure them to get them talking later. So for the Canadian perspective, this statement does not work. I will acknowledge that this statement would work a lot better for the US market. But at this stage, we're in agreement. So at this point, our positions have joined, which is shut up. So moving on.
And from that point, keep that like name, rank, and serial number. You're being recorded on the officer's body cam, maybe on a dash cam. The jury will see you were cooperative. You gave essentially the same emergency statements a police officer would make at a shooting scene to the investigating officers. You have been polite. You have not evinced the guilty behavior that they associate from watching TV. Here's how the cops interact with, how the bad guys interact with the cops. And that you are on video stating, officer, you'll have my full cooperation after I've spoken with counsel.
So there's some stuff here that I really like. First, be polite. Even though you're going to be under stress, try to remain polite at all times and just indicate, I want to talk to a lawyer. don't say, I wouldn't say, make any promises that you're going to be fully cooperative, because then the jury might wonder later on, why didn't this guy make a statement? Well, because making a statement is a bad idea. The Crown wouldn't be able to say, this guy should have made a statement, because that's an improper argument. But if you put that on a recording, then the jury's going to be thinking it because you're putting it in their heads. Why would you want to put something in the jury's head that the Crown isn't allowed to because it's, considered improper? But I do like the be polite, stand up for yourself. And the whole thing about, repeating a mantra like sort of name, rank, and serial number, that's good advice. That's one of the tactics people can use to successfully avoid sort of police questioning, is to, stand with, I spoke to a lawyer. He advised me not to say anything. Well, what about this? I spoke to a lawyer. He advised me not to say anything. And that sort of mantra technique can be really effective. So there's a lot of good here. The other thing I'll point out is that when he says that this is what a police officer would potentially give at a shooting, keep in mind, you're not a police officer. Well, probably. And police officers are going to be in a very different perspective with respect to a shooting than you are. The things that work for a police officer might not be the things that work for you. So that's a big cautionary note here, because the experience of police officers is going to be different. And also the views of police officers with respect to the behavior of police officers. Police like to think of themselves as, we're going to figure out who's lying and who's telling the truth. We're going to figure out what happened. We're going to do the right thing. We are the good guys. But they fail to recognize that the police aren't always the good guys in people's story. If you're Ian Thompson and you've just had to defend your home against people firebombing it, the police, to him, were not the good guy in that story. I'm sure they wanted to be. I'm sure they tried to be, but they weren't. So the sort of expectation that's boiled into a lot of this advice is basically from a position of the police are going to figure out everything that happened and do the right thing. But you can't rely on this hope that they're going to do the right thing for you, because situation after situation has shown us people where they haven't done the right thing. And I wouldn't want to risk it.
What I hear here, the attorneys are really worried about you saying too much. People develop logorrhea, right? Diarrhea of the mouth after adrenaline dumps. And what Moss, I think, gives us is a pathway to not say too much, but not say nothing.
The problem is so many people out there either haven't been trained at all, or they focus their training on, when do I shoot him? Can I shoot him this way? Can I shoot him this other way? Can I shoot him in this third hypothetical scenario?
Right.
And they've never really seriously discussed handling the aftermath, except how long does it take to say, never talk to the police? Okay, less than 3 seconds.
Right.
And they've had 3 seconds of preparation, and that's all they fall back on.
The problem here is that the gap between saying nothing and saying too much isn't this broad gap. It's really razor thin. It will be hard to see daylight in between those two things. So when somebody says, I'm not going to say nothing, but I'm also not going to say too much, I'm going to operate in that sort of safe space that's in between those two things, to my mind, that's a statement of overconfidence, maybe a statement that's a little unrealistic, because the example that sort of leaps to mind is if somebody hands you a grape and says, I want you to walk 50 meters downrange. I want you to place that grape in between your lips, and I want you to turn your head to the side, and I'm going to use this handgun and shoot that grape out of your mouth. At that point, I'd be saying, listen, your margin for error on that is really, really narrow. And if you get it wrong, the consequences are huge, because, my face may not be the most attractive face, but I like the things it does in terms of, I can chew food with it. It doesn't horrify children. It may not be the most attractive, but I don't have people recoiling in horror from it. Those kinds of things, which might change if somebody were to miss that grape by an inch and blow a hole in my head. There's other consequences if they miss it by a little more than an inch. So I don't necessarily want to trust in that ability. And in the same way, I wouldn't say, go ahead and trust that you can operate in that space, especially because you won't even know where the edges are. You're not going to know what too much looks like. So you're just aiming for that space in the dark. Not only are you 50 yards downrange, it's in pitch black. You can make that shot, great, but I'm not going to try it, and I'm not going to be the guy standing downrange, and I'm certainly not going to tell you that it's okay to do that. So whenever somebody says, that there's that safe gap, there really isn't. And there's not sort of a space that you could navigate there. Especially, there's not a space that you can navigate there when you're under stress. And, he talks about you need to prepare for this and that this is something you need to plan out. The problem is, I can do a drill for what do I do, with a failure to feed? What do I do, with a stovepipe? Those kinds of things I can drill for. I can, make sure that that just my natural reaction is going to solve that problem. But there isn't really a drill that you can do for what you do encountering the police after, a self-defense shooting, because you're not going to be able to practice that. You don't have police officers who are willing to run you through that. And you're not going to be able to practice it with the whole court proceeding to see how it worked out. You're not going to be able to practice it while under, that sort of stress and panic and fear. So the notion that you can practice this and get good enough at it so that you can just do it by rote, I don't see it. I don't think this is not a risk I'd be personally willing to take. So that's my my sort of response to that.
So if you take that path, and I've had a lot of people that the attorneys that go, man, I think that this is really hard advice. Okay, then if you don't like the other advice, this is the path to walk. Well, you're the expert in it.
My answer to that would be this. If you don't think that you can handle that, if you don't think you can memorize 5 things, how many things did you have to memorize when you learned how to fight in the first place?
And then they got so good you didn't think about them anymore.
Yeah, people say, oh, well, I'll be panicked, I won't remember it. If you panic, why are you walking around among us and our children and our grandchildren carrying a loaded gun?
As a Canadian, of course, I'm not able to carry around a loaded handgun, so that part of the question is just not there. However, the thing that sort of springs to my mind in terms of this bit of discussion is that when we're talking about defensive shooting, the advice usually given is to shoot for the torso. And the reason why is that the torso is a big, slow-moving part of the body as compared to extremities. If you're running, your legs are moving really fast, but your torso moves much slower. And it's likely to incapacitate. We actively advise against trick shooting. You don't want to try to shoot the gun out of somebody's hand. You don't want to try to shoot somebody's leg. And the reason for that is that we expect that you are, if you are in a defensive situation, you're going to be impaired as compared to your range performance. You're not going to be as good, in that situation because of the adrenaline, and possibly also because you might be wounded. You might be engaging in defensive action because that other person has already attacked you. They might have shot you and you're now firing back. And so, you're not at your best. Right here, in terms of what to, thinking of what to do afterwards, you need to also think of the fact that you are going to be not at your best. This isn't about, can you remember 5 things? That's a really sort of facile way of explaining it. It's not just remembering 5 things. It's can you execute them perfectly in a scenario where getting it even a little bit wrong has life-destroying consequences. Are you that good? I'm not. I don't think you are either. And so, this isn't just, can you remember 5 things? It's, are you going to be good enough in that moment to pull this off? I don't think so. I say, aim for the torso, keep your mouth shut, talk to your lawyer, let your lawyer do the talking, let the lawyer be your mouthpiece because that's what you're paying them for, because your lawyer isn't going to talk you into jail, we hope. So I think that this is really failing to recognize just how dangerous this is. If you get it a little bit wrong, there's no margin for error because eventually a jury is going to decide your fate. And juries sometimes will be swayed by just one little thing you might have said. That might be the end of your case. So I guess in summary, I almost entirely disagree with Mr. Ayoob here, and that's kind of a hard thing for me to say because he's a figure I have tremendous respect for. He's a guy who has done a lot of, for the self-defense, for the sort of firearms community. But on this one, I think he's just mostly wrong. And, he recognizes, I'm sure here, that, defense lawyers have a different position. And, ultimately, you're the one who's going to decide. If you're in this situation, again, talk to a lawyer, get legal advice specific to what you're dealing with, because everything you have now and everything you have planned for your life, if you are ever in a self-defense, fatality situation, everything that you have and want to ever have is at stake. That's the table stakes that you're gambling with. So that's a hand I'd play cautiously, but you can decide for yourself ultimately what you want to do. Anyway, thank you for watching. I hope this has been informative. I hope it's been educational. This has been sort of a hard video to do, partially just because I'm, again, disagreeing with somebody I've got tremendous respect for. But please, I hope this has been something, helpful to you. And if it has, please like the video, please share it, please subscribe to see more content. As I noted, I've cut a lot of content out from the original. I've tried to keep sort of I didn't want to be unfair to the arguments being made, but I tried to cut out sort of as much extraneous stuff as possible. So I recommend you check out the original video. Again, it's by Active Self-Protection Extras. They're a great channel. You should check out their stuff as well. Maybe buy some of their merch. But anyway, once again, thank you. Thank you as well to my Patreon supporters at the $50 level: DMO, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, Toronto Airsoft, and Rail. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. And at the $10 level, Ma Buddy Keith, Process Eng, Stephen Larson, General Counsel of the CCFR, John Robinson, TR, Roy Haddock, Freckles Dack, Jean-Alexandre Tessier, Sir Goat, Sights and Arms Limited, Chubba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Brekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, DF, Stacey Cartmell, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stephen Conquest, Darren Duell, Sean Crane, Ian Hutchinson, Rory, Travis, BC Bushcraft Leather, John Singarty, Misa Komarevich, All Systems Go, David Moga, Ian Hedgedanek, Hello from Venezuela, Taylor Delnea, Rod Guzman, Matthew Nesbitt, Conway Youre, James Cox, Zip Ties and Bias Plies, Daniel Kang, Jean-Guy Toussaint, Richard, and Brock Watts. Once again, thank you for your support. I apologize. I think I've turned a 10-minute video into a 45-minute video with my response, but I've had a lot of people say, what do you think of this particular advice? And so here's what I think. Let me know what you think in the comments below, because, maybe you think I'm out to lunch on this one. Anyway, thank you for watching, and I hope I've armed you with knowledge.